I just wanted to welcome you all to the Sole Proprietor versus LLC Managing Risks webinar. This webinar is done in partnership with the Vermont Small Business Law Center and the Financial Futures Programs at CVOEO. Just a bit of housekeeping to go over. I'll keep the recording on so that folks can view this after the session is over. For those that are unable to join, they can use it as a resource for years to come, hopefully. We ask you to mute yourself when you're not speaking and make sure that your name shows up in the Zoom window so that we're able to call on you if you have a question. Speaking of, you can enter your questions in the chat. I will be monitoring this and we'll make sure we get around to all of them. After the workshop, we'll make sure that you receive an email with all of our contact information, as well as links to resources that we mentioned, and a copy of this presentation, as well as these introductory slides. Just a small overview of the Microbusiness Development Program at CVOEO. So our program is statewide. Our program specifically works within Chittenden, Addison, Franklin, and Grand Isle counties. We help low to moderate income Vermonters start and expand their businesses, and there's no fee for any of our services for those that are income eligible. If you would like to see if you qualify, we have contacts for Simeon Geigel and John Gergley below, who are two of our counselors, but you would be welcome to send me a follow-up email after this presentation as well. Just a quick thank you to our partners, first of which is People's Trust Company. Our contact there is Jay Cummings, and you're able to reach out to him as well. Some of our other partners are the regional development corporations in the area. Here's some of their logos. I'll have their contact information in the follow-up email as well. I mentioned that the Microbusiness Development Program is regional. For counties that we do not cover, we have partners in Bennington, Rutland, Washington, Lamoille, East and West Orange counties, Caledonia, Essex, Orleans, Windham, and Windsor County. You can see if you qualify and connect with a coach if you click on the mbdp.org website, or again, email me if you'd like to learn more. Here's some additional supports for your business. If you're not already connected, we will be, again, sending these slides after the fact so that you're able to explore them on your own time. And without further ado, I will pass it over to today's presenter, Brian Bailey. Thank you.
Thanks, Sophia. I will share my screen. Welcome, everybody. Hello, hello. So we're here with the Vermont Small Business Law Center, housed by the Vermont Law and Graduate School. Got a couple of our students and a few familiar faces in the crowd today. So we're going to talk about sole proprietors versus LLC, kind of business entities more generally. What are they? Why do we use them? What's their purpose? And, you know, one of their purposes, as we'll see, is managing risk, but they're not the only way to do that. So we'll get into some other strategies as well. We have a small enough group today that I'd say we could definitely open this up for questions, interruptions. It's all good. You know, if we want to make this more conversational, I'm totally fine with that. So if something, you know, if anyone has a question or wants to sort of drill down on any of these topics, feel free to just let us know that. You can put a message in the chat. You can just sort of raise a hand or just unmute and, you know, hey, excuse me, you know, I have a question about that. So that's all good. Don't worry about that. So without further ado, we can jump into this. And by the way, speaking of that chat, I will endeavor to keep an eye on that. But maybe, Sophia, if you see somebody has a question or whatever, you can also just let us know.
Absolutely.
Awesome. So I'm Brian Bailey. Hello. I'm a staff attorney with the Small Business Law Center. We also have with us today Christina Williams, who is a 3L. For those who don't know, that means she's getting towards done with law school. She's one of our student clinicians this semester and is going to help us out with this presentation. So what are we talking about today? I went over a bit of that, right? The notion of enterprise, business enterprises and business entities, what they are, how they work, separation of debt and assets, how that interplays with entities' operating agreements. Those belong to LLCs. There are also other kinds of agreements, as we'll see, for other kinds of business entities. That is a very commonly missed aspect of creating an LLC, which is the most common form. Some of you may already have LLCs. And if you are like, I would say 9 out of 10 of the folks that we see coming through our clinic uh, who have an LLC already, most, I'd say 9 out of 10, don't have an operating agreement, but it's a good idea, as you'll see. We can get into nonprofits as well. If that's of interest to this group, if it is not of interest to anyone in this group, then we'll sort of lightweight that part of the discussion. Same thing with these hybrid entities, sort of low profit organizations and other things. We can talk a bit about that. So, feel free to let us know in the chat or elsewhere if nonprofits are or are specifically not of interest to you. And then more broadly, risk and liability, how do we deal with it? So let's start at, 10,000-ish feet. What's an enterprise? What are we even talking about here, right? Enterprise, project or undertaking, that's difficult or requires effort. That's what entrepreneurs are doing, right? They're engaging in enterprise. They're trying to do something to achieve some kind of goal or bring something into the world. And it's not easy. And it involves a lot of risk. I like to say that, lawyers are all about mitigating risk. Our job is to see risk, and we are risk-averse creatures. Entrepreneurs are risk takers. That's just comes with the job, right? If we want to start a business and bring a business into the world, that's a risky enterprise every time. And it doesn't have to be an existential risk or a grave risk to your, person or your, um, prospects for the future, but it's still risky and there's always a chance of failure. So we're going to talk about how to mitigate that. So it's the entrepreneurs who are doing this work, bringing all these pieces together, the people, the funding, the resources to engage their enterprise. So there are different models for how this is done. And the two main ones are the for-profit organizations, that's LLCs and corporations, and can also be other things like co-ops that we'll touch on briefly, or the nonprofit organizations. Usually that's a 501c3 public charity, although there are lots of nonprofit organizations other than public charities. We'll touch on that briefly. Probably the public charities is the only thing that's going to be of interest to this group, and it's the only thing of interest to most groups. But there are a lot of different entity types, and we're going to get into that. And it depends, which one you choose depends on what you're trying to do. Okay, so here is sort of the quick chart of the various different entities that are most commonly chosen, and even some of these are not that common. So the first two are sole proprietorship and partnership. We say that the government requirements for these are low. Actually, they're something close to zero because these are the default entities that are assigned when a new business just is formed and starts doing something, unless the business intentionally chooses one of these others. So if I'm a new business person and I have created a really cool new widget and I'm going to go out there and sell it to people who need widgets. And so I just start making them in my garage and I create a website, start selling them. And I'm off to the races. I have a business, but I haven't created any of these other business entities. Then I am a sole proprietorship. So the partnership is just that thing, but with more than one person. So if there's a couple people now who are coming together in their garage, making the widgets and selling them, those people are in a partnership automatically. That's what we call it, and that's what is recognized in the law. When we think about tax in that regard, Sole proprietorships and partnerships, that's pass-through taxation. What does that mean? It just means that we're still going to file that 1040 or 1040 easy or whatever it is at the end of the year, our usual personal tax return, but the business income shows up on the personal tax return. Particularly, the business income shows up typically on something called a Schedule C, which some of you may be familiar with. And that's the place where we tell the IRS, I've got a business, here's the name of the business, it made some money, here's the income I got from the business. That happens on Schedule C, and that's what pass-through taxation looks like. And there's self-employment taxes as well that can show up there. So then we get into the LLC. We highlighted the LLC form because it is by far the most common choice for small businesses and new startups. There's a good reason for that. The government requirements for setting up and maintaining an LLC, we're calling that out as medium here. But actually, it's pretty easy. Some of you probably already have LLCs and know that it's pretty much just a form that gets filed with the Secretary of State in the state that you want the LLC to reside in. So could be Vermont, doesn't have to be Vermont. It's possible for a Vermonter or anyone living in any state to set up LLCs in other states. And we can talk about why someone might do that, although it's a little uncommon, and usually you're setting up an LLC in the state of your residence. So the actual process in Vermont is just going to the Vermont Secretary of State's website, where they have a section for business filings, and just basically filling out the form. When we fill out that form, we're creating something called Articles of Organization, where we tell the Secretary of State, here's the name of the company, here's the members of the company, and so on, the details. And so it's possible to just sort of go through that form, create it, and voila, it's done. So as we'll see, LLCs provide limited liability. So do corporations, B Corps, nonprofits, and co-ops. All these intentional forms create a limited liability structure that can shield the owners from the liabilities of the business. And that's a big difference between what sole proprietorships and partnerships will do. When we think about taxation in the LLC world, they are by default pass-through taxation. So just like a sole proprietorship or a partnership, Schedule C income. But LLCs can elect to be taxed like a corporation. That means that the business files its own separate tax return and pays its own taxes, the corporate tax at the corporate tax rate. There are the reasons for choosing one or the other pretty much beyond my scope. That is a question really for an accountant. By the way, it's a great idea to try to get an accountant if you can. They're not easy to find in Vermont, but they're pretty useful for businesses. So that's LLC. The other one that's most typically chosen would be a corporation. And there's two flavors, the C Corp and the S Corp. S Corp is generally like a smaller business, and it's a simpler form. S Corps actually can be taxed as a pass-through, just like LLCs, but unlike LLCs, their default is corporate taxation. S Corps have a limited number of shareholders, and they're sort of designed to be closely held. Whereas C Corps, that's the sort of corporation that we usually think of when we think about corporations, right? 3M, Ford, GM, Eli Lilly, right? Those are C Corps. The benefit of a C Corp is that it can issue different kinds of shares. So both S Corp and C Corp are usually going to be appropriate for businesses where they're going to want to be attracting outside investment. And in order to do that, they want to be able to issue shares to people who are going to invest in the business and want to become an owner of the business, but aren't necessarily going to run it. It's possible for LLCs to do that, but the corporation form is really set up and tailor-made for that kind of purpose, where we get to issue shares and give little fractional pieces of the enterprise to the investors according to whatever rules we've set out for doing so. In S corps, there's kind of a limit on how much of that you can do. There's only one class of shares, whereas in C corps, we can have multiple classes of shares, and they get all the sort of complicated Rube Goldberg things that happen when corporations get really big and have lots of different investors. So we can talk more about all that. Just to get quickly into these others, there's the benefit corporation or the B Corp. So that's just like a corporation of the C or S flavor, but it gets to state a mission in its Secretary of State filing and in its bylaws. So B Corps have a reason for being that is something other than maximizing profit. So these are, we can talk a little bit more about that when we get into nonprofits, but B Corps get to make profit, but they are articulating to the world that they have some other reason for being, and it's usually going to be something that's akin to a nonprofit style, social benefit or something along those lines. And so sometimes that's a good choice. The nonprofit, of course, does something similar. It articulates its reason for being. But in the case of a nonprofit, it isn't allowed to make profits. It doesn't have shares. It doesn't have owners. Nonprofits are owned by the public, but run by the insiders who are the board of directors and others within the nonprofit. So, nice thing about nonprofit, they're exempt from income tax, as you probably know. Some taxes may apply. As a general matter, nonprofits are fairly high on the government requirements piece. They require a lot of work to get them going and to maintain them, and we're going to talk more about that a little bit later. And then, of course, there's co-ops, which are pretty popular actually in Vermont. There's lots of different kinds of rules around co-ops. We can talk about that. We're going to get into it briefly towards the end. But that's a situation where we've got various people coming together who are all going to be sort of co-owners, and we can bring people in and out of the organization on that basis. Okay. So I'm going to pass it to Christina, who's going to tell us a little more about this entity idea and what that means. So Christina, what do you think?
Yes. So Brian talked a little bit about liability shielding owners, and that can be a real reason why we choose certain entities. And so here we have the LLCs, limited partnerships, corporations. When we choose a certain entity, we want to remain and understand the distinction between a person and between the entity. And so this is kind of where you have to put your understanding on what business you have chosen and how to maintain that. And so that's really what we're talking about here is maintaining your entity. So limiting liability, separating personal assets from business assets. So you may have a home, you may have a vehicle, and so understanding how you sign for things of that nature needs to be separated between like your LLC and your personal name, and separating earnings as well. And so Brian really loves to share a little bit of imagery about a business hat. And so when you're making business transactions for your LLC or for your partnership or for your corporation, you have your business hat on for that specific transaction. And then maybe you want to, for example, go out to eat with your family, you have your personal hat on in those moments. And so just understanding that these really need to be separate in all aspects. And one of the things I've noticed more recently is really just taking an initial step to go ahead and create a new bank account for your LLC. So things of that nature really allow you to separate your personal assets from your business assets, and then keep those different hats on throughout the transactions that you're making. And so next we'll go into sole proprietorships and partnerships. As Brian mentioned earlier, this is going to be the default. And so if you aren't necessarily choosing an entity to start with, like this is where it will trickle back to. And so as far as assets, you can have, again, your house, your vehicle, things of that nature. These are automatically commingled with the operations that you do for your business services that you provide. So thinking later down the line, which you may not initially start with thinking when you're creating your business, you know, a breach of contract or a debt, you know, those things can come back and take away like these assets. And so creditors can collect any owner's personal assets to satisfy business debts. And so you may not think of this when you start off your business, but you know, way down the line, you'll maybe have different vendors, different people that you're working with, and things can happen. And so it's important to understand what liability you provide for yourself in those different interests. And so who is this for? You have different professionals. Liability can pass through regardless, as Brian had mentioned with the earlier slide, and then businesses without a physical presence. So we can think of for example, there is an attorney I know, and they just go and they provide simple advice to others, and they may do it over the means of like a Zoom call like we are on today. And so they don't have anything physical to work with. People aren't coming and stepping on their property. And so there's no liability there for different things like slip and falls, things of that nature. And businesses without risk. And we can
Wherever
go.
that may be, right?
Yep. Yeah.
If you can think of one.
Yes. And so the LLC, so this is definitely the common choice. Some of you all may already have LLCs and be operating in LLCs. And this is where the liability, the limited liability comes in. And so when you have your things like I've mentioned already. So like your home, your vehicle, and you have your business assets. Those things can be separated, but you have to, again, keep the things that you're doing um, and I guess like the maintenance of it separate as well. So they are automatically separated, but sometimes, depending on how you practice your transactions, it can all be blended back together. So again, we want to remember to maintain those things separate because that is the entity that you've chosen, and this is best to maintain the limited liability. And so what this sets up is that creditors down the line ordinarily cannot collect any of your assets, like your personal assets. And so again, just you have to keep in mind that there is like a distinction, you know, this is for me personally and this is for my business. And so if you're a business who intends to remain small and you have a small group of owners, this is the correct choice for you. And businesses who do not intend to attract money from strangers. So that can mean a range of things. You can be trying to get money from other people, you know, fundraising of that sorts, and that's not necessarily where you want to be for this specific one. Brian, do you have anything to add?
Yeah, I mean, so what we're seeing between sole proprietorships on the one hand, right, where we have commingled assets, and LLCs on the other hand, where the assets are separated. This is the key thing for most small businesses, that the creditors cannot collect against your personal assets. So this is the reason LLCs are so popular, because the owner has personal stuff, the house, you know, equity in their home, their personal car, their personal bank accounts that are used to buy groceries for the family and so forth. Well, all those personal assets are reachable by creditors against the business if it's a sole proprietorship or a partnership. And in fact, it's kind of almost worse than that when we think about a partnership, because creditors can collect any owner's personal assets to satisfy business debts. So when we think about a partnership, maybe we've got two partners who are collaborating on the business, and maybe one of those partners does the bad thing and creates a liability that the business will then have to satisfy. Well, the other owner who didn't do the bad thing maybe has more assets, right? Maybe owns their home outright or their car. That partner who didn't do the bad thing is just as reachable as the partner who did, because they're both partners within the organization. So, the sole proprietorship and the partnership, that's a risky proposition for most businesses because personal assets can be reached. And so when we think about, well, why does anyone ever do this? Sometimes, like Christina said, professionals, where the liability is going to pass through regardless, right? So I have a law practice. If I commit malpractice, it doesn't matter that I have an LLC. Malpractice always attaches to the individual. Doctors are the same. So, sometimes they don't much care about the LLC protection because it doesn't matter from the perspective of professional liability. But even then, if you've got a law office and you have a physical place where people come and show up and meet with you, it might make sense to have the LLC because someone can just get hurt in your building. And we have just a classic slip and fall. So that's risk that an LLC can protect the owners,
And
or yeah, go ahead, Christina.
Brian, we have a question in the chat before
Oh,
we
yeah.
move away from liability. Someone asked, why would you not want to be an LLC instead of a sole proprietorship?
Yeah, I think, it's hard to conjure situations where a sole proprietorship would be the intentional choice. The only thing I can think of or that I've come across is like a lawyer, and it could probably apply to other professionals who don't have a physical presence. They work out of their home, they counsel clients from time to time, but don't have a physical place where clients come, and all the liability that could, possibly arise from that lawyer's activities with the business, that's all professional liability, right? And so then the LLC doesn't do anything for you because the professional liability will pass through. For pretty much everyone else, I think the LLC is probably going to be a useful form because they're trying to protect their personal assets from creditors. And when we think, by the way, about creditors, like who is that? We think about, okay, well, maybe I didn't pay my landlord and they become a creditor. Okay, fine, wonderful. That can happen. And that's one form of creditor. It can also be people suing for breach of contract. It can be plaintiffs who have some kind of grievance, right? It can be product liability. Lots of different ways to sort of imagine the things that can go wrong. Of course, that's what lawyers do for a living. Any other questions on LLCs? Yeah, Heidi.
Yeah, thank you. So I just registered an LLC within the last couple months, and I'm in the transition of startup. So I understand intellectually how to keep things clean and clear, and I have a bank account for the LLC, but I don't have a credit limit yet, or so some of the startup costs are very blurry. Like I'm putting them on my personal credit card, possibly. How do I? And this might be in the weeds too much, but how do I move from what essentially was a sole proprietorship kind of thing to the LLC, knowing that it's going to be blurry as I transition?
Yeah.
I don't, yeah.
Yeah, that's a good question. So first of all, the instinct to keep things separate and clean and to have a clean division between personal life over here and business life over there, that's a good instinct. right? Because we want to keep things separate. So keeping clean divisions between the business on the one hand and the personal stuff on the other hand is important for maintaining the limited liability that is afforded by an LLC or a corporation or any of these other forms. Keeping a separate bank account is probably thing one for most people who are starting new LLCs. That's a very sort of crucial separation. To answer your question, right, how do we clean this up? Because we started things with personal funds, and then the LLC gets formed somewhere along the way. It gets its own bank account. But in the meantime, the owner has been feeding the LLC with various things and assets and funds and so forth. The answer to that question is the operating agreement does that job, among other things, usually. One of the we're going to talk about operating agreements in a bit, but one of the things operating agreements do is specify what the capital contributions of the owner or owners is to the organization. So that's the place where we can say, business, I gave you a laptop and I gave you $2,000 and maybe I gave you a car or something like that, right? And I capitalized the business with this money and stuff. And we're going to, assign a value to the stuff and business. Now those things are yours, right? So that's called capital contributions. And that's something we usually deal with in the operating agreement. One other thing I'll just note here, which I maybe didn't say as clearly as I usually do when we think about LLCs and other organizations that are being created, corporations or whatever. When an LLC gets made, right, the form gets filled out at the Secretary of State and the LLC comes into being. That's a new legal person. So in the eyes of the law, someone's been born, and that someone can sue and be sued, can make contracts with others, can have its own bank accounts, and can do all the legal things that humans can do. So when we think about this separation, and like Christina said, the habit of mind of the separation, part of that comes from understanding that the LLC is a person, as far as the law is concerned. That's why it gets to have its own bank account. It gets its own bank account with an EIN number, right? Which you probably already got, Heidi, right? We go to the IRS and we say, IRS, I've created a new person. It needs a personal identifier, like a social security number, and the IRS gives it one, calls it the EIN. So, and then we can take the EIN to the bank and say, bank, I made a new person. Here's the EIN number. Please give the person a bank account so they can have assets and things in their own name. So thinking, the habit of mind is largely about being clear when I'm operating on behalf of the business or I'm operating on behalf of myself. One of the ways that I like to clarify this is with an example of getting a check in the mail. So, I'm operating my business, I have clients, I'm selling widgets, whatever, and I get a check. And it's like, oh yeah, I got paid. So then the questions are, open up the envelope. Who's the check written out to? To me or to the business? If it's written out to me, then hopefully it's for something personal, right? My friend paying me back for, our groceries at Costco that we split. But if the check is to my business, then hopefully it's for business, right? I'm getting paid by a client or a customer. And so hopefully the check is written out to the appropriate party, given whatever we know about why it's coming to us. Then we take the check to the bank. Where does it go? If it's a business check, it goes to the business account. How does it get signed? This is something that is kind of a little best practice that people miss. How do we sign checks? Well, the business signs the check. Remember, the business is a person. How does the business sign a check? It's a person, but no hands, right? It signs the check through its owners. or other authorized officers. How do we do that? In the case of an LLC, we would do our regular signature and then comma member. And when we put that comma member on our signature line, that's a way of indicating to whoever's going to read that signature, I didn't sign it. It's not me, the person. It's the business using my hands to sign. So we sign the check by signing for the business, and then we hand it over and put it in the business account. What if we're going to take that check and use it to pay the mortgage? And I own the house personally, right? My business doesn't own my house. I own my house, the human. And I need to pay the mortgage. And I want to use the business proceeds to pay the mortgage. Shouldn't I just take the check and put it in my personal account? No, that's not a best practice. The best practice is to take the check, put it in the business account where it belongs, and then the business can pay its owner. That can be in the form of a salary, which is where the business is paying the owner twice a month or every 2 weeks or whatever. Or it can be in the form of a draw, which is a lot more common with new businesses, where we say, I'm not getting a salary, but when there's extra money sitting around in the business account, I'm just going to draw it out. And so that's a draw. So I can take the check, put it in the business account, and immediately turn around and take that exact same amount as a draw and put it in my personal account. That's the nice clean division where we're saying the business got its money and then it paid me, the owner. And I can go then and use that to pay my mortgage. Why would we go to the extra step? Because if we get sued, a judge is going to look at all this stuff. And if the judge can't figure out whose is whose, if the bank accounts are a big jumbled mess, or there is no separate bank account for the organization, and the organization is paying the mortgage, meanwhile, money for the business is coming into the personal account, and it's just, you can't make heads or tails of where the income streams begin and end. That's a point where the judge, that's one of the reasons a judge can do a thing called piercing the corporate veil, which we're going to talk about. That's where the limited liability can break down. We're going to get into that. Hopefully I haven't fast forwarded too much, Christina, and all the other stuff we're going to talk about. Are there other questions on this stuff
You answered them. All good.
while we're here? All right. There will be time for more as we go. So Christina, you want to talk about corporations, and then I'll take over for or wait, no, I'm talking about corporations. That's right.
You got it.
Okay, so we talked about these a little bit previously. So assets, right, in the LLC, separated. Creditors cannot collect an owner's personal assets to satisfy business debts. Same thing with corporations. They have limited liability, just like an LLC has, and the assets are separate. The difference is that now with corporations, very often investors come into the mix. And so we end up with this division between, well, who owns the business on one hand and who's running the business on the other hand. So when we think about LLCs, LLCs have members. That's what we call the owners in the LLC context. Corporations can have shareholders and they're owners, but they also have officers, and those are people who run the thing. So the shareholders are the people who own the shares of the business. And so we all know that, corporations, like out on the public markets, for example, I can go out and buy a share of Microsoft and I become a shareholder. Now I own a little piece of that business, little, emphasis on little, but I own a piece of it. I don't get to run the business. There are shareholders' rights, and that's a whole thing. But the people who run the business are the ones with a C at the beginning of their title, right? Chief something officer or president, or however you want to call that. So when we think about corporations, the big difference is that because they have this structure of shares in the business, they are designed to be owned by people who aren't necessarily running it. And the people who run it don't necessarily have to own the business, right? Or don't have to own enough to control it. So, we can have kind of the C-suite executives who are out there doing the day-to-day, but we can have a whole big class of shareholders. Sometimes those are the same people. And so if we think about a C corporation that's getting started from scratch, well, the shareholder and the owners are the same, right? It's maybe there's 3 people and they are president, secretary, and treasurer of the organization, and they all own 33.3% of the shares, right? That's completely typical. But as the organization grows, right, who's this for? As the organization grows and we want to be able to sort of disperse little chunks of ownership so that we can attract capital, that's where we start sending away some of the shares without necessarily giving up or giving up our right to run the business or bringing in others to run it. So S corps are most common for small businesses who probably are going to remain on the small side, but want to be able to sort of disperse ownership. C corps are really a more common choice for businesses that want to scale. So when we think about, people like anyone who's looking to be acquired or to get venture capital or some kind of professionalized investment in the future, those people are going to choose C corps. In part because they're an inherently better structure because of their multiple tiers of shares and so forth, and the other corporate governance kind of structures built around them. But also just as a practical matter, because if you're going to a venture capital firm and saying, please give me money, they're going to expect you to be a C corp. They work with C corps, and that's what they expect. It's not that a venture capital firm can't give money to an LLC or an S corp. They're just not used to doing that. And so it's going to be harder to make that work. Okay, we're going to move on from entities. We're going to talk more a little bit towards the end about nonprofits. But does anyone have questions? Any other questions about the entity space before we sort of get into some of those stuff?
I do have a quick question.
Yeah.
I'm thinking back about the consultation that we had, I believe last week. The person commingled, so basically the business and the personal expenses were commingled. They paid the mortgage and whatnot, everything. And then now the person is coming in and saying, well, how do I cure it? How do I make it clean? What do I do? I remember remember that one. I was just interested, how do you do it? Do you have to basically dissolve LLC at this point, start a new one, or what is the process, if any, at all? Thank you.
Yeah, that's a good question, right? And that's a relevant question because we're about to talk about an operating agreement, which is one of the ways you can do that. And more generally, I think the way you would typically do that, it depends on kind of whether there are third parties who are interested in this state of affairs, because if there are, then their interests and legal rights would have to be accounted for. But if it's sort of more of a situation that we often see where we get someone who created an LLC 2, 3, 4, 5 years ago, running the business, it's all going fine, whatever, as far as they think, and then they kind of realize all these years into it, like, oh, I'm supposed to be thinking about this as like a separate thing, like I'm supposed to have a separate bank account, really? Like I thought I just set it and forget it's an LLC and I'm done. And that's not really the case. So how would I remedy a situation like that? Probably with an agreement. And that could be the operating agreement, which we're about to talk about more, or just some other kind of agreement where we just sort of say, okay, all these things have happened in the past. There's this kind of jumbled mess situation that we are currently in. And we too, right, if I'm thinking about a single member LLC, that agreement, just like the operating agreement, is going to be between 2 people, the human owner and the business, who's a person, remember. So those 2 people are going to come together and say, all right, we're going to settle this all now. Roughly you, human, have given me this much stuff and money. and I, organization, have paid your mortgage this many times, and this is kind of what the balance sheet looks like, and we're going to tally it all up, and at the end somebody owes somebody else some money, and we're going to transfer that money from one account to the other and call it a good day. And that might be sufficient. If there's no third parties hanging around who have an interest in this, in the outcome of this situation, that's going to be a lot better than nothing. It's not going to be as good as having done it right in the first place, because it's probably impossible to figure out exactly to the penny what the numbers should be. But better late than never. And we're going to talk about that. Like, that's also true for operating agreements with LLCs, right? Because so many LLCs do not have operating agreements. That's okay. It's better to have it upon formation of the organization, and it's better to have it a year in as opposed to 2 years in. So an LLC, the operating agreement can be done whenever. Sooner the better. So Christina, I think you're going to talk through operating agreements a bit, yes?
Yes, this is one of my favorite pieces because it's your little government of your business, right? And so operating agreement, it's going to begin with honestly whatever you can think of. I would definitely recommend when you envision your business, thinking of how it's going to be structured, how it's going to be ran, jotting different things on a little sticky note and get started, just letting your brain go out. So first thing, roles and responsibilities, as Brian mentioned. One person ownership of an LLC, for example, versus multiple ownership, it's going to look different, right? So there are just going to be things that don't make sense to be listed as a one-person ownership versus somebody who is versus a organization or a company who has multiple ownerships. And I'll get into the gist of that below. And so, for example, how decisions are going to be made. So basically you can go and write in your operating agreement, say there's 5 business owners. You can say that 3 have to agree in order for a decision to be made. And then that's how we're going to go about these kind of decision-making things. Or you can say that, so and so of the 5 owners is going to be the manager of this business, and they have the full authority to make all of these business decisions that are involved with employment or vendors. You can get as specific as you want to, but how decisions are made in some aspect is going to be very key. And then next, growing the business. So bringing in new owners or how an owner wants to leave, how you can uh, basically, if you put in money to start your business, and the owner wants to leave, how are you going to go about either giving them back their money or selling it to a new owner? You want to talk about those things in your operating agreement. Taking debt and investment dollars very similarly. If things don't work out, like who is going to be responsible for paying this portion and this portion, and how are you going to split that up amongst the owners? And then lastly, one thing that people definitely don't think about when you are beginning your business is how to wind down or closing the business. So how owners are separated, and then the process in which we're going to go about doing all of these things. So when you can begin the process of winding up or closing down your business, there's going to be rules inside of that. And so that's all that's going to happen here in the operating agreement is how are we going to start to like break things down? Who is going to be in charge of, taking care of this or taking care of this? And you can put all of these pieces inside of your operating agreement. It genuinely is going to be your bread and butter for like solving anything down the line, because if you put it right here, like this is going to be, as the title says, the Constitution. So it's going to be the breathing document like for your business, and I honestly say whatever that you can think of, write it down, put it in here. It is going to just be very, very key document. And I believe Nick.
So
Yep, go
do
ahead.
we have a couple of LLCs in the crowd, yeah? People who've already created them? Does anyone who has an LLC already also have an operating agreement currently? So usually most businesses don't. So here's the thing about operating agreements. They aren't required, but they are a good idea. And the reason they're a good idea is because without an operating agreement, there are a set of default rules which will apply instead. And those default rules are written by legislatures. And legislatures have a job, and their job is not to protect the owners of businesses. Their job is to work on behalf of taxpayers. So they don't really care what happens when one owner decides to leave, but the other two owners are going to stay in the business. It's not their problem, right? But the business owners care a lot about that situation. So, like Christina said, there's kind of this fork in the road regarding roles and responsibilities if we're going to be a single member LLC versus a multi-member LLC. For a single member LLC, reasonable minds differ on whether an operating agreement is needed at all. I think it's a good idea, even for a single member LLC, because a few things can be done in the agreement. One, the business can indemnify the owner broadly. And that's basically, I think we're going to talk about indemnification. That's a way for the business to say, whatever happens, whatever kind of trouble we get into here, human, I'll be responsible, me, the business. That can be useful. Also, things like succession can be thought of in connection with the operating agreement, and that's true for either a single owner or multiple owners, where we're thinking through, well, what happens if I get hit by the proverbial bus or the actual bus, and I'm in a hospital bed, unable to run my business? What then? Well, the operating agreement can talk about that. It can say, if I become unavailable, I'm going to name somebody who will be empowered to operate as a manager of the business. So they're not owning it, but they are a manager, which, by the way, is a thing in LLCs. So we have the members we talked about. There is the idea of a manager-managed LLC, where the members own it, but somebody else is running it, sort of like a corporation, except it's just a single manager, or one of the members can be named as a manager who gets to do all the things, and everyone else can just sit there and own it. But we can name a manager temporarily for unavailability. So that's a single member thing. But if we're thinking about multi-member LLCs, now we get into all this other stuff that Christina was saying. Well, how are we going to bring on new owners? What if somebody wants to leave? How are we going to do that? Particularly, what if somebody wants to leave? Because this is a place where trouble happens very often with multi-member businesses, right? It's a business divorce. We're having somebody who is saying, I'm out. I want out. I'm leaving the business. And that tends to be kind of fraught and can be quite difficult. And for that reason, an operating agreement is usually going to be very specific, have a very clear and detailed roadmap for how the owner will leave. One of the things it often includes is a right of first refusal. And what that means is that the remaining owners of the business, get to buy out the leaving owner on the same terms as whatever other buyer there may be. So imagine we've got three owners, one of them's on the way out, and they propose to sell their interest in the business to third party, someone else completely not inside the business. Well, the remaining two owners maybe don't really want to suddenly have that third party outsider coming in, because that's not what they envisioned. They don't want to have that person be a co-owner with them. Nevertheless, the leaving owner has an interest in the business that they own and that is theirs to dispose of. And so they say, well, I don't really care if you want to work with that person or not. I'm selling my interest to them. That's where the right of first refusal comes in. That's where the existing business owners can say, okay, well, whatever terms you've got with that new person that you're proposing to sell your interest to, whatever those terms are, we'll take that deal. So you were going to sell your interest for $100,000. Okay, we'll buy it for $100,000, just the two of us, and we don't have to take on this third person in the ownership structure that we don't want in here. So that's a big one, the right of first refusal, but also just the process for evaluating what the ownership, amount is. How much money is this ownership worth? And what are we going to do if somebody dies and we've got an estate involved and heirs? So it's going to usually have some very specific processes for dealing with situations like that. By the way, we've been talking about operating agreements. That's the thing for LLCs. The analogous thing for corporations, that's bylaws. Bylaws are written differently, but they do a lot of the same kind of stuff. They talk about how we're going to make decisions, how we're going to grow the business, how we're going to shrink or close the business, roles and responsibilities, and so on. By the way, another thing, we'll say at the end, so we at this SBLC offer a program where business owners in Vermont can get connected to attorneys for up to 10 hours of free legal advice. And those attorneys get paid what we call a low bono rate. It's a lot less than a typical hourly rate for an attorney, but it's enough to keep the lights on, and lots of attorneys are interested and participate in it. The operating agreement and just the overall process for setting up a new LLC or any other kind of business is a common and good way to use that attorney time for people who want it. We'll have some QR codes and stuff at the end of the slides to let people know how they can access that program. Super useful. Operating agreements are not hard. They are sort of formulaic, but there are decisions to make, and it's worth it for business owners to kind of understand what's in that agreement. What kind of promises are we making? And does that fit with our vision or doesn't it? Right? Like, for example, majority versus unanimity, and particularly in two owner situations. I've had some where they say, no, we trust each other implicitly, and we want both people to be able to just make decisions on behalf of the entire business, and that's how we want it. That means one person can go enter into a contract that the other person wouldn't necessarily agree with. So it's a little risky, but it's also efficient because you don't have to always meet and agree on everything. People can just be out there doing stuff. So, that's a discussion that is usually had while we're hammering out an operating agreement. Any questions at this juncture? We're going to move on.
Yeah.
Heidi, question? Yeah.
Yeah. I was just playing with the mute button. So are there templates or examples that are credible? So I'm in process to be talking with an attorney, getting matched, and I think it's probably wise for me to do something ahead of that time. But Google searches or, are there templates that are easily findable that could be a starting place to respond to for operating agreements for a single member LLC?
Yeah. Once upon a time, the Secretary of State of Vermont had a template, but they took it down because someone complained that that was the unauthorized practice of law. I
Okay.
don't know if it was or wasn't, but now it's no longer out there. You know, companies like LegalZoom and the other sort of template people who are reputable. I mean, basically, if you're paying for the service, then you can probably assume that you're getting something for the money. If it's free, maybe it needs to be a little more scrutiny there.
Okay.
You know, but people could, I mean, it's totally possible for ChatGPT to write an operating agreement. Whether that would be worth anything, I don't know. In part because every time you ask it that question, it gives you a different output, you know, so which one was it? You know, I will say that in general, having something in writing is better than not having anything in writing, just with respect to agreements, broadly speaking. Um, you know, not having anything in writing is a very challenging situation when it comes to contracts, and operating agreements are just a kind of contract. It can always be replaced with a more professional work product in the future. But if that's just not available, then coming up with something that makes sense. And here's the thing, when working with forms, if you know you're looking at a form and don't understand, like, well, I don't know what that means, then I think it makes sense to talk to a lawyer before signing on. Because if you don't know what it means, there's a chance that it means something that you didn't intend or that is explicitly bad for you. So yeah, forms are risky, but they can be used by savvy business people, and they are used all the time.
Thank you.
Yeah. So CYA, cover your assets. We talked about this idea of the corporate veil. So limited liability applies if there is what we call a veil of separation between the individuals in the business. That's the corporate veil. And we like that thing to be opaque and thick and impenetrable. You could think of, I like to think of it this way, and we're going to refer back to this in a little bit when we talk about insurance. We can conceive of ourselves, the owners, we're the human, and we're trying to protect our assets, our human assets, the equity in our home and our cars and bank accounts, and so forth, right? The LLC or the corporation or whatever entity we've formed, that's another person who stands between us and a creditor, right? Who's the creditor? It's some aggrieved party who thinks the business owes them money. So that's the landlord who says you breached our lease agreement. It's the counterparty who says you breached our contract. It's the plaintiff who says you did a bad thing and you owe me money because I'm suing you for some sort of civil damages. So whoever that creditor is out there in the world, the LLC stands between you, the human, and that creditor. So the corporate veil is the thing that is sitting between you and the LLC. It is possible for a judge, when reviewing the claims of the creditor, to pierce the corporate veil and reach into the pockets of the human after all. That's not supposed to happen. That's not what limited liability means. But it can happen, and we talked about that. It can happen because there isn't a clean division or separation between the human and the LLC. The judge can't determine where the corporate veil is or isn't, and so says, I'm just going to ignore it. It can also happen if the LLC is inadequately capitalized So that's like a shell company, right? I think we all have this idea of a shell company probably in our heads where we think about, yeah, it's registered with the Secretary of State and it exists as an LLC, but everyone knows there's nothing there, right? It doesn't really do anything, and it doesn't, and particularly, it doesn't own anything. So it doesn't have enough in its, if it has a bank account at all, it doesn't have enough in its bank account to meet its reasonably foreseeable expenses. So if we have an LLC that operates in a commercial space, let's say, and that commercial space has rent due and maybe other costs and expenses that are associated with it, well, the bank accounts better have enough to meet those reasonably foreseeable expenses. If it doesn't have that, it might be inadequately capitalized. It's like a shell company now. It should also probably own the things that it uses. So if we think about like a landscaping business that's set up as an LLC, does it own its equipment? You know, landscaping is pretty heavy on the equipment. There's a lot of capital assets in that world. If the LLC doesn't own those things, it might be inadequately capitalized, where a judge is going to say, yeah, I see that you've got an LLC there, but it doesn't own any of its equipment. It doesn't have enough money in its bank account to meet its reasonably foreseeable expenses. I'm going to say that's something like a shell company, and I'm going to pierce the corporate veil and reach into your pockets. Because I think you were just playing a game here. You're just trying to shield yourself from liability without running a real company, right? So that's kind of how that works. So, you know, separate assets, that's what we're talking about here. So the assets owned by you, the person, could be leased to the business as well. And that's another option. So in some cases, the business should own its assets, but in some cases it shouldn't. So let's think about this is common for a lot of us, myself included. We run businesses out of our homes these days. A lot of people do that. It's really, really common in Vermont. So we've got a lot of small businesses who are doing one thing or another, and it doesn't make sense to have a separate space for the business. So here's an issue that comes up with that. The home is almost certainly not owned by the business, but it is being used by the business. If we think about that creditor hanging around out there, and the creditor wants to reach into the pockets of the person because they get more assets that way, more things, more money to collect their judgment. Are they going to make an argument that the home is a business asset? Well, if the business is run out of the home, there's probably an argument there. And so I don't know how that would play out if someone were trying to make that argument, but I can say that if the homeowner is acting as a landlord to the business and has a lease agreement with the business that says, business, I'm going to let you use my garage, and you're going to live in my garage, business, because you're a person and you can live there, but you're not a human, so it doesn't get too cold for you. And so the garage is yours, that's the business space, and you're going to rent it from me, and you're going to pay me some amount of money that I've come up with, $500 a month or something. And that's the rent, and we're going to have a lease agreement and so forth. In a situation like that, it's very, very clear that the business does not own any part of the home. It's operating out of the home, but that's a rented space owned only by the human and not at all by the business. So something like a lease agreement in a case like that maybe makes sense because, again, it creates that clean division, and it makes it very, very clear that there's no argument whatsoever that the home is a business asset. It's owned by the human alone, and it's protected by the corporate veil. Bank accounts, we've talked about this, right? So avoiding commingling of funds. Lawyers are very sensitive to this because we have ethical violations if we do that. But just in the context of a regular business, keeping funds separate, like we've been talking about, good idea. We talked about the EIN that you can get from an IRS. And just documenting, clean files, having a file for the business, sitting in a filing cabinet somewhere, or having a, you know, a folder in the computer that where all the stuff for the business is kept, and you know where to find it, and just tidiness overall, good idea. So the operating agreement, by the way, right? We've been talking about the operating agreement or the bylaws. The Secretary of State will not accept an operating agreement in Vermont. So as a practical matter, when the operating agreement gets signed, what happens to it? It goes in the file. So we look in the file, we can see there's the operating agreement, we can refer back to it if we need to. Partnership agreements, the same thing, right? Or bylaws or whatever. Charters, all the documents are living in one place and can be found there. Again, clean divisions, habit of mind, companies over there, companies different from me. Yeah, so we've been talking about piercing the corporate veil. That's where an owner becomes personally responsible. And so when does an LLC not protect the owner? Well, for one thing, an owner can still be personally responsible for hurting someone, right? If I'm out driving around and I get into a car accident because I blew a stop sign and I injured the other person in the other car, I'm probably personally liable for that, even if I'm operating on behalf of my business, right? It depends on kind of what's happening there. But if I'm personally responsible, right? So if maybe I'm out on business duty driving the company car, but I had a couple of beers for lunch and I blew the stop sign, LLC is not protecting me. I'm personally responsible for that. That's my personal error in judgment that led to the car accident. And so it's not like that's even though I'm driving the company car and I'm out on business, I'm personally responsible, so I'm going to be personally liable. Failing to separate, we've been talking about that. No separate bank account, income streams and asset ownership not clearly delineated, not adequately capitalized, doesn't own its assets. Here's a big one. What if the owner personally guarantees the debt? Heidi, this kind of goes to your point earlier. Like I'm a brand new startup and I have my LLC, but I still need to borrow money from somebody. Am I really protected? If a brand new LLC that doesn't have much in the way of history or doesn't own very much, right? The LLC doesn't own things yet. It just exists. Even if it is adequately capitalized, maybe its foreseeable expenses are $100 a month. And so adequately capitalized means $1,000 in a bank account and you're all set, right? Or whatever it is. But I'm going to go sign a lease, a 10-year lease that over the course of the 10 years is worth hundreds of thousands of dollars. Is the landlord going to accept my $1,000 in adequately capitalized bank account assets as essentially collateral for that obligation? Not likely. How is the landlord going to get around the LLC protection? They're going to ask for a personal guarantee. So this is a separate agreement that goes with the lease agreement and says, if the business can't pay the debts, then the human owners will pay it instead. And in this way, the landlord has gotten completely around the limited liability protections that the LLC affords. So personal guarantees, very common for new businesses. And just be aware that if we're seeing that, that means the LLC person standing between you and that landlord is going to just step aside because the landlord asked him to. That's all they need to do if they have a personal guarantee. All right, any questions? We're going to get into nonprofits. First of all, questions. Second of all, is anyone particularly interested in nonprofits or particularly knows they aren't interested in this? We can hear about that. We can go through this, but we can sort of give more or less detail depending on whether. So it looks like Robert's interested in the nonprofit space. Lots of people are. It's super common. So, all right, we'll go through these. So, Christina, back to you.
All
Tell
right.
us about
So
nonprofits.
yes. What is a nonprofit? So a nonprofit, it's going to be an organization that is formed for a public benefit, a mutual benefit, other than obviously like pursuing profit. So it's not for making profits. Common purposes common purposes, um, like these examples, hospitals, schools, colleges. So there's some kind of charitable purpose, an educational purpose, religious, scientific. Um, that's really where it kind of sits on like what a nonprofit organization is going to be. So they're generally, um, they're always granted tax exempt status. And it's really interesting when it comes to, how the nonprofits, are funded and they make the money. And so nonprofits can make a surplus. Um, but that surplus, it has to go back into the nonprofit. And so it's not ever distributed into like other private individuals of the nonprofit organization. It's key to remember that. Um, and then all contributions made to them are tax deductible as long as they are properly registered. And I'll get into the proper registration in the next slide, but before starting, you're gonna want to plan around the mission. So you're gonna want to draft a mission statement, something that's clear, something that's concise, and it proposes all of the like guided activities that are going to be inside of this nonprofit. Um, you're going to want to choose a nonprofit like organization type. So the most common you'll probably hear about is a 501c3. There are others, but that's the most common. These are complex and they're high maintenance, and so you're going to need to know the filing requirements, the taxation, specifically, when you think of taxation, you may think of the tax exempt, right? But for Vermont specifically, like there's still sales tax. So depending on, what your service is, you're still gonna have to like charge that on your things and make sure that your accounting represents that. And then there's always fiscal sponsorship. So, this is a big kind of meaty process of going into nonprofit and filing, the organization type, mission statements, all those things. You even have to have a board for a nonprofit, board of directors. And so sometimes it can just be easier to sit under a already built nonprofit and work under them. And so that's going to be called fiscal sponsorship. And it's not as easy as I just made it seem, but that's the idea of it, is that you are not going through all of the filing things that starting a nonprofit from scratch has to go into. And Brian, we can go to the next slide. So nonprofit rules and practice, again, there's a lot to do when creating a nonprofit. So establishing and observing formality matters, corporate actions and structure, as I mentioned. You're going to have a board of directors. In the state of Vermont, Vermont requires at least 3 directors to oversee the nonprofit. There's bank accounts and ownership, and then the necessary filings. So with the 501c3, I believe Brian may have touched on this a little bit earlier, but there's the IRS form 1023 and 1023 EZ, and you have to get into these first. And so these are you can't skip this part. They must be filed. And so business registration, you'll have to go through and get a business account number through Vermont. And then a charity registration as well through the Vermont AG's office. If you are ever soliciting donations. So there's quite a few rules in regard to what exactly you are doing if you're a nonprofit in Vermont. And then filing an annual report as well. So other Vermont rules and requirements, employment. So when you get into employment, regardless if you are for profit or nonprofit, you have to you're required to have like an unemployment insurance. So thinking of those things, those benefits, the accommodations, there are things that you're gonna have to look into. So you're gonna have to follow the Vermont and federal employment laws. So those are just gonna always be the same. I already mentioned sales and other taxes, so it really depends. You don't always have to, I guess, file your nonprofit in Vermont, but if you do, like the sales tax, those things are going to be as I mentioned. And then when it comes to payroll taxes, you're gonna have to withhold and pay things like the Medicare and the state federal income taxes, all of those things. And there are going to be different rules for whatever the nonprofit is. So as I mentioned earlier, you can be in education, and if you are going to be handling childcare in any of the aspects, like Vermont has specific rules that you have to follow in regard to those things as well. Next, a big question we see quite often is, can I change my for-profit company to a nonprofit or vice versa? And honestly, I would love to tell people, no, you can't do it. But it is possible, but it's very, very hard to do so. For-profit to nonprofit, you're looking at successor disclosures and rules. And so, how you have to just think about all of these things. So we talked a little bit earlier about operating agreements. And so those things are going to be set up a little bit differently when it's a nonprofit. And then for nonprofit to for-profit, there's winding up restrictions, and it's very, very hard to close down the nonprofit and switch it to a for-profit company because it really is going beyond the mission that you desired in the first place. And so just the restrictions around it are very hard to like go about in changing that. So if you're not really sure, think about the fiscal sponsorship, think about other avenues where you can kind of fit under something else and you won't necessarily have this kind of like issue if you want to like potentially move to something else later. And private interment is always lurking. So, like, where is your money going? Is it going to someone, kind of secretively? It's kind of, is it fraudulent? Because it just really depends on how you're moving your money around. And Brian, if you want to add any ideas to that as well.
Sure. Yeah. So in terms of going from for-profit to nonprofit, the issue there is, how's the IRS going to feel about taking a bunch of money that would have been taxed as a profit and instead saying, nope, it's not subject to taxation because we're a nonprofit now. So if it feels like money laundering, then that or could be called, could be described as such. That's the sort of situation where the nonprofit rules are going to be a liability because the IRS is sensitive to people trying to use nonprofit organizations not as a way of benefiting the public, but as a way of avoiding tax. And you might be shocked to hear this, but people try it. So that's the reason nonprofit organizations are subject to such heavy scrutiny? Because, this is why we can't have nice things. People try to abuse the nonprofit structure to avoid paying tax when they otherwise would have had to pay it. When we're thinking about going from nonprofit to for-profit, the issue there is that nonprofits can never distribute profit. So it's not like there's shareholders out there that can get a distribution because we wound up the company and ended up with a bunch of assets sitting around that were like, okay, cool, well, executive director, you get this much, and all you board of directors, you each get a share. No, that's not how this works. When a nonprofit dissolves, its assets must all go to either another nonprofit similarly situated, or if you can't find one or don't want to give it to another nonprofit, you can give it to the government. Those are your two options for nonprofits' assets. So this is something that people don't always appreciate, that when we start a nonprofit organization and then build it up full of assets, right, it ends up owning its facility. It ends up owning a fleet of vehicles. It ends up owning a bunch of stuff. That stuff can never be, removed from the organization and redistributed. That's not how this works, right? So now it is the case. So let's talk about private inurement. Private inurement is where insiders are getting a benefit from the organization by virtue of their position as an insider. And that is not allowed. So what is allowed? A reasonable salary. So the executive director can be paid. That's fine. It's no problem, right? It's not like we can't be paid for working for a nonprofit. Some people are paid quite well who work for nonprofits, but they're being paid a salary, not profits, and their salary must be reasonable. There's a whole big body of law built up around what a reasonable salary is, because again, as you can imagine, there are some corners of our economy where people are pushing on the boundaries regarding what a reasonable salary is. So, it's at a high level, it's whatever a person would be, the person who is, say, the executive director of the American Red Cross or some other huge nonprofit, and you have to attract these people from private industry where they could be making a salary as CEO of a for-profit company. And to get them, you have to pay them some comparable salary to the one they would have made at the for-profit, right? So that's probably a reasonable salary. So there's plenty of room to play there, and salaries can be, very livable and even high working for a nonprofit, but it still must be reasonable, and sometimes this is an issue. The problem comes when we're stepping outside of that salary and we're getting into private inurement. An example I like to use there is, I don't know why, I guess I like cars, and I always think about cars. So let's again imagine that there's a company car, but now it's owned by the nonprofit. And let's say they're in childcare. So, they use the car to ferry kids back and forth to like field trips and whatever. And one day the executive director says, that car sits every day from, 9 to 3, except when we're doing field trips. And I have to go pick up my daughter from preschool at noon. So why don't I just take the car and pick up my daughter? Because no one's using it anyway. And executive directors start taking the car and using it to pick up their daughter. Well, no, you can't do that. That's a private inurement. The car is owned by the nonprofit, and the executive director is an insider getting a benefit, the use of the car, from the nonprofit. That's private inurement, can't do it, puts the entire nonprofit enterprise and its public charity status, 501c3 status, at risk. So, you might be asking, well, so the car just has to sit from 9 to 3 every day? Like, why can't the ED use the car? The executive director can use the car. But to use the car, what needs to happen? there needs to be a rental agreement or some kind of lease agreement in place that has to be negotiated at arm's length, has to be fair, which means the executive director cannot vote on that deal. The other board members, the executive director has to leave the room while everyone's talking about, can the ED use the car? And if so, under what terms? How much is she going to pay for this? And so on. What's a car worth? What would, Hertz charge to use a car for an hour once a day? And, there's other things that can come into it, but it has to be a fair deal. So this, by the way, is one of the reasons we have to have at least 3 on the board of directors, and Vermont suggests that there be 7 on the board of directors for a nonprofit organization. Part of the reason we like to have 7 is so that we can deal with conflicts of interest, because they always come up. And they usually come up in this private inurement space, where the executive director says, I want to use the car, and I'm going to step out of the room while you all decide, can I use the car? And if so, how much do I have to pay for that? And the other 6 still have a quorum and can easily get the job done, right? 4 of them would typically need to vote in favor of that deal. So when we think about nonprofits, it's just like any other tax advantaged situation. We're thinking about, will this organization survive an audit? And it's the same as when we file our personal taxes. At the end of the year, we tell the government things that the government takes on faith are true. And maybe they are and maybe they aren't, right? People do lie on their taxes. And every year, a bunch of people get audited, and some of them turn out to have lied, right? So it's the same thing in nonprofit space. If we're doing it right, we've thought about all these problems, and we've got everything in order. And if the government comes a knocking to audit our nonprofit next year, we're going to have all the documents. First of all, we know we've done everything right. And second of all, we know we can prove it if the government asks, right? So the IRS gets wind that the ED's been using the car to pick up her daughter. And we're like, oh yeah, no problem. Yeah, we've got the rental agreement right here. Here's the minutes from the meeting where the board voted to let her do it. And, we're charging $25 a day, which, we did some research and found out that was a reasonable number, yada, yada, yada. Right? So nonprofits are challenging because of this stuff. Which gets back to the point Christina was making about, what about fiscal sponsorships? This is why people choose fiscal sponsorships, because they don't want to run their own nonprofit. They don't want to go find 7 board members who are already serving on 2 other boards for 2 other nonprofits somewhere and don't necessarily want to serve on a 3rd one. And so we don't create a brand new nonprofit. Instead, we go find an existing nonprofit whose mission is aligned with what we want to do. And we say, bring us under your wing, please. And we'll do a fiscal sponsorship agreement where we become a program of your organization. And so we don't need 7 new board members. They're already doing all the things. They know about private inurement, and they're watching out for that. And they're having meetings and keeping minutes and filing their annual tax returns and all the things. And we just get to go out there and do the work. And we get to take tax deductible donations that come into our sponsor, and the sponsor passes them along to us, usually with something off the top so they can run their own organization and pay their own bills and do their own overhead. So fiscal sponsorships are popular for that reason. Sometimes it makes sense to start a brand new nonprofit, but very often it makes sense to start out as a fiscal sponsoree and grow the organization, create all the funding streams and the networks of people and all that, and then say, okay, we've gotten big enough now, we're going to become our own thing and do our own nonprofit creation. So Christina's going to talk a little bit about some of the alternatives to nonprofits for people who are scared by all the things we've just said. But before we get into that, questions on nonprofits? It's complicated. All right.
Yes, Brian,
Yeah, Robert.
I have a question.
Yeah.
So on the other side of the coin of nonprofits, I consult for several nonprofits here down here in Brattleboro. And this is probably into the weeds of taxation, but I'll just throw it out there. If I reduce my uh, hourly rate because it's a nonprofit and I think I'm doing a good thing or the right thing, it's up to me. Is there any upside, downside, taxation wise for me providing a service for a nonprofit?
Well, I'll start by saying I don't know. But what I can also say is that when we think about a nonprofit, it's a corporation.
Right.
Almost always, there's ways to make nonprofits that aren't corporations, but they're virtually always a corporation.
Right.
And they're run just like that. And they pay all the people who help them do their thing just like they pay everybody else. So from the perspective of the person working for the organization, I'm not aware of any difference. It's just a client, right? A company that's paying for my service. It gets a little bit stickier when you're on the board, right? Now, when the person providing the service is on the board, we're right back to private inurement.
Right.
We have to watch out for that. There are special situations for professionals who serve on the board and also provide their nonprofit with service, right? So again, like lawyers who can be on the board and can also do legal service for the nonprofit. And sometimes that's permissible. I'm getting a little further afield, but one thing I'll say that your comment brought up for me is sometimes people say, well, I charge the nonprofit like half of my normal rate to do the work for them. So there's no problem with private inurement because it's obviously fair. Sorry, that's not how this works. If you're an insider and doing work for the nonprofit, it actually doesn't matter whether it's objectively a fair rate or not. It can still be a private inurement. There are ways around that, again, just like there are ways around the executive director wanting to use the car. But it has to be done the right way in order for the organization to remain audit proof.
Okay. So it's funny you mentioned that because I've sat on board meetings to present my findings. I'm not on the board. Some of these that I work for are very, very small. And I thought maybe the right thing to do would be to give them a reduced rate, even though they pay their employees, like you said, and the executive director is well paid, etc. And I'm wondering if I did that, could I somehow use the other half of my rate because I cut it in half as an expense? I don't know. That's a taxation question, I guess.
Yeah, that's a question for a CPA. I'm not aware of anything that would let you do that, but that doesn't mean it doesn't exist.
Right, right.
My
Okay.
accountant set me straight on my own. I run a, I have in addition to teaching at the law school, I run a solo practice and, you know, I finally got sick of DIYing it and got an accountant and they immediately were like, oh, you're doing this wrong. Granted, not wrong in a way that meant I was not paying taxes, wrong in a way that meant I was paying more tax than I needed to, right? So,
Yeah.
yeah,
One other
accountants
question.
are usually worth it.
On the garage issue with say the landscape guy keeps his equipment in the garage and he rents it to himself for $500 a month. Doesn't that get into the weeds of landlord, tenant, taxation, profit, etc.? Or is that very clean if it's LLC? Like if I were to rent my little office in my little house, say it's 10% of the square foot, and I rented it to my LLC, does that go off into a whole nother bailiwick or what?
Well, so like in terms of landlord tenant law, there might be some duties there, but luckily, the the one who's likely to sue you is you. So you're probably will drop the suit. But there are also taxation things there.
Right,
So if we think about that, like, does that end up being an expense, for example? And that depends on the way things are taxed. This gets into, again, not an expert here, except in my own experience, but that touches on this pass-through versus corporate taxation that we talked about earlier.
yeah,
So LLCs are automatically a pass-through organization.
right,
Sometimes it makes sense for an LLC to elect to be taxed like a corporation just for tax reasons.
right,
Um, I have heard that the crossover point there is like it depends on the tax situation of the individual human owner. Um, so it's going to be different for everybody, but that the crossover point is like 60, 70-ish thousand dollars coming in as profit to the organization per year. Like around there is the crossover point where it maybe starts making sense to switch from pass-through taxation to corporate taxation. And that raises all these other questions about then the owner becomes an employee of their own organization and they can pay themselves a salary and maybe there's a lease agreement, and other things happening like that. So the tax implications are definitely a piece of that question.
yeah. I can imagine because when you were bringing up that example, I thought, all right, so the landscaper owns his house. He's paying himself $500 a month. Now he's got rental income. Is that $500 a month an expense on his LLC? It gets really, really complex, I would imagine. So there must be a tipping point, like you said before, that it even comes into play.
Yeah, there is, and that's why CPAs are a thing,
Right,
because they can look at your particular tax situation and say, yeah, this makes sense for you, and here's how we're going to do this, right?
right, right,
And sometimes there's actually, because most small businesses are going to start with pass-through taxation because it's easier.
right,
The organization, an LLC that is passed as a tax-through organization is regarded by the IRS as they call that a disregarded entity, which
right.
means
I've
they're
heard
sort
that.
of like doesn't exist,
Right, right,
Um,
right,
and so that's easy, right, for the business owners. But sometimes there's a little pot of gold on the other side of doing it the hard way. And that's where CPAs can justify their expense sometimes, right? Where it's like, hey, I'm going to pay you however many hundreds of dollars a year to do taxes for me, but you're going to save me more than that
right,
because you know how to do things that I never figured out how to do, which is
right,
exactly the situation I ended up in.
right. Okay, thank you.
Yeah. All right, so let's talk about hybrid entities. Christina, I think you're on this one.
Yes, I'm gonna go a little quicker on this so we can finish up on
Surprisingly,
time.
we're running low on time.
Yeah.
At
All
first I
right,
thought,
so
no way, but yeah, no, we're going to run out.
low profit limited liability company. So this is going to be a hybrid between a nonprofit and a for-profit LLC. It's going to prioritize charitable social missions, but it allows the for-profit aspect of it. I believe Vermont was the first state to allow L3Cs, which is very cool. Its tax is treated like a regular LLC, pays taxes on the profits. It's owned privately, usually, often by the founders or investors. And the funding advantage is that it may attract foundation program related investments, so that can be a real benefit. Um, Next is benefit corporations. So this is going to be a for-profit corporation that has some kind of commitment to public benefit. Um, Yes, to me, they're very interesting B Corps. The purpose of it is to combine the profit making with some kind of social goal or environmental goal. The governance of this is going to be, again, the directors, and it's going to be their job to consider the impact on communities, workers, environment. The taxation is going to be very similar to a S corp or just a regular C corp. It's going to depend on how it's set up. And then for this, you're going to need a certification. So it's supposedly optional, but it's a B Lab certification. It's kind of where this started up. And so this is going to just give it the credibility it needs to be the B Corp. So you can think of, I believe, company like Patagonia, I believe is a B Corp. And then you have your co-ops. So you have your consumer co-op, worker co-op, producer co-op. So the consumer, the shoppers, the customers own it. The worker co-op, the employees own it. The producer co-ops, it's usually small kind of producer, farmer, etc., who owns the producer co-ops. And, those purposes, they all kind of range. So you're going to get better products, you want to share your ownership, or you're wanting to like collaborate to reduce the cost and, reach particular markets. So for this, you're going to want to register under Vermont's cooperative corporations law. So co-ops, they may or may not be tax exempt. It's going to be dependent on the structure. So it really, you want to get into the nitty-gritty, I definitely recommend you guys come sign up with us and we can walk you through more of the process of what that looks like for your particular idea.
All right. Yeah. If anyone has questions about that, you could put them in the chat, which I have just started monitoring, by the way, and I see there's a couple of questions in here that we haven't addressed, and so I think we'll have a few minutes at the end, and I'll get into some of that. And do feel free to keep asking questions as well. It's okay if we run out of time. So let's talk about some other ideas regarding managing risk and liability. So we've been talking about this idea of the creditor, right? However they arrive, whether it's a plaintiff or a landlord or a counterparty in a contract, they create a business liability by saying, you owe me money. So one of the ways, other than creating an LLC and managing it properly, to manage this kind of risk is, of course, insurance. So lots of different kinds of insurance out there. For businesses, general liability insurance is kind of the catch-all. It's like the homeowner's policy for a business. It kind of covers the usual stuff, that the kinds of trouble that businesses get into, like injury to somebody on your property, the classic slip and fall, that sort of thing. Those insurance policies are usually pretty reasonable and cover lots of different stuff, all the kind of workaday liabilities that businesses can get into. There's also professional liability insurance. We've been talking about that. That has to do with professional services. So lawyers carry it, doctors carry it, other kinds of professionals can carry it. Basically, if you are a licensed professional in the state of Vermont, chances are, by virtue of that licensure, you're considered a professional who can get professional liability insurance. The thing to remember about professional liability, like we said earlier, is that it attaches to the individual as a rule, and an LLC doesn't protect against professional liability. So that's why professional liability insurance is so important for professionals. You can have the LLC all day long and manage it perfectly. If it's a professional liability issue, then the LLC will not serve as a shield. For those who have employees, workers' compensation insurance, just making sure that there's insurance to cover potential losses in a workers' comp claim. Product liability, so for businesses that are making stuff and sending the stuff to others, right? Injury from products made or sold by the business, product liability insurance is a thing for that. A thing to remember about insurance, broadly speaking, is It's like another shield. So we've been talking about sort of the shield of the limited liability entity that stands between the creditor and the human. Insurance is another one, and it stands between the creditor and the business, or sometimes between the creditor and the human directly if we're talking about professional liability. But before the business even has to pay a claim, insurance can step in and say, no, 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 we got this. So we're not even going to worry about whether the business is adequately capitalized, and we're not going to be thinking about what does the business own and how much is on the hook here, because the insurance is going to step in and pay the claim. In addition to that, an underappreciated benefit of insurance is that it very often, like a general liability clauses and professional liability clauses, and insurance generally, often has a defense built into it. So the insurance says, not only will we pay a claim if the plaintiff wins, but we're going to send our lawyers to court and try to make sure the plaintiff doesn't win. The insurance company likes this because they don't want to pay the claim, and the business owner likes this because they don't want the insurance company paying the claim either. So that ability to have the insurance company in the corner of the business where there's a lawsuit happening can be huge. Sometimes that's as important as their ability to pay the claim in the first place. They have the ability to defend. And they have a cadre of lawyers who are in their employ and do this all day long. So sometimes it's hard for small businesses to access that kind of legal firepower, but insurance companies do it all day long. So having those people in your corner can be really, really beneficial. That's a good thing about insurance. Let's talk about a bad thing about insurance. That's exclusions. So when you look at an insurance policy, which I recommend you because it is dry, they are hard to read. The insurance companies have not yet caught up to plain language in law. But the way they're written is there's the insurance policy at the top. We're going to cover you if bad things happen. And then below that, the much longer exclusions. Here's all the times when we won't cover you. When we think about homeowners insurance, floods are classic exclusions. So insurance policy says, if your home gets destroyed, we'll buy you a new one. Great. And then the exclusion says, oh, but if it gets destroyed because it was a flood, we won't buy you a new one, right? If you want flood coverage, that's a separate thing and you have to buy it separately. So watch out for exclusions. That's a way that insurance companies can deny claims. And after all, insurance companies are as much in the business of denying claims as they are in the business of paying claims. They will surely pay the claim if they're required to, and they'll surely not pay the claim if they aren't. So just another thing to keep in mind, reporting rules, right? Businesses, when we own businesses, we have ongoing commitments. There's the annual report. People miss this. When we create an LLC, we have to go back and tell the Secretary of State again each year, hey, yep, still operating, still out there. And here's your 35 bucks, right? So that's something that has to be done. Regulatory requirements, got to watch out for that, like childcare, as Christina was saying, or whatever else. Come to us if you want to talk about regulatory stuff. Inspections, kind of related, right? Do we need to prove to the state that we're doing things in a safe way or not polluting? Sometimes that's an issue. Insurance policies we talked about, tax filings. So, you know, if it's not a pass-through entity, the business is going to have its own tax reporting. Nonprofit organizations have annual tax reporting requirements. And, you know, looking at agreements. So when we think about, we haven't talked about contracts much this session, but, you know, looking at contracts, being aware, did it expire? Is there some obligation we need to keep up with? So just keeping all that stuff on the calendar. So, right, we need to think about what our legal structure is going to be. Am I going to be an LLC? Do I, for some reason, want to be a sole proprietorship? Is a corporation a better fit for me? You can think about the entity types, think about the rules that govern it, particularly in nonprofit space. Be deliberate about this. By the way, when we're thinking about agreements and contracts, good idea to write that down. Like I said earlier, a written agreement is almost always better than some kind of verbal agreement. Verbal agreements are usually a bad idea. Written agreements are a better idea. So you can come to us to get more specific legal help. This form will take you to our legal assistance help webpage, and we can get you connected to an attorney. You can also get personalized education like what we've been doing here. So if you have a particular question or there's something we didn't cover and you're interested in it and you need to know more information, we can give you that. We'll do a 45-minute individualized education session. And you can also get connected to an attorney. Like I said before, you get up to 10 hours of free legal services. For those who have attended this session today, if you feel like you're kind of ready to be connected to an attorney and don't need more education, you could ask us for that directly. These usually the 45-minute education sessions are sort of a gatekeeping function to being connected to an attorney, but because you've been here today, you could skip that part if you want to. So you can let us know about that. Robert asked earlier, my LLC is in Vermont. Do I have protection if I perform services in another state? LLCs are recognized in other states. The limited liability attaches kind of regardless of where we are. And in fact, right, so we don't have to have an LLC in every state in order to do business in other states. There are all sorts of questions that swirl around that, where will I be sued if I'm going to get sued? Am I going to get sued in my state or their state? That's a contractual question very often. It's a jurisdictional question having to do with all sorts of legal arcanery that I won't bore you with right now. The short answer is, yeah, an LLC in Vermont applies to activities in other states. Other questions? We've got a couple minutes. I thought we might have like half an hour, but no. But that's good because you guys were asking questions along the way, so that's great.
Yeah, I've got
Robert,
another one.
yeah.
Right. Did I cut somebody off?
Nope.
Okay. Interesting to say that the errors and omission, well, you mentioned that an LLC does not protect me against my professional liability. Yes, I hold some licenses and I do consultation. So if something came up, I've got $1 million liability, $50,000 errors and omissions. If that 50,000 didn't cover, it sounds like that's covering me personally, not the LLC, even though the LLC pays for it.
Professional liability insurance in general will cover the professional. Sometimes it depends on the profession. I think sometimes the insurance company will name the business as an additional insured. I'm not sure, why they would necessarily do that, but I've seen that done. So, right. Either way, they're standing between the important thing is that they're standing between the human and the creditor,
Right.
but they're also standing between the business and the creditor. And in some cases, maybe that's relevant, right? Even in a professional liability context.
Right. So I guess my question is, if the 50,000 didn't cover the claim, would it roll over into general liability? Would they come after me personally?
It depends on whether it rolls over will depend on what's in the policy. So I don't know about that, but what I can say
Okay.
is that if the policy doesn't cover the full liability, then typically the business or the individual, depending on who's on the hook, is going to be the one responsible for whatever remains. So if there's additional liability beyond what's covered, then the plaintiff can come after the business or the individual in the case of a professional liability situation, and try to collect the rest. So that's
Okay.
how that works. As a practical matter, a lot of times plaintiffs will just say, whatever, I got paid, I'm gonna be done with this. But that's an issue. And by the way the limited liability sort of works in the real world with businesses is that if a creditor comes after the business, let's say they've got a claim for $1 million and the business is capitalized at 150,000, the creditor they liquidate the business, they get all 150K out of the business, and they've got 850 left on their judgment. But they can't pierce the corporate veil and try to go after personal assets. What happens to the LLC? It declares bankruptcy, right? And it just says, okay, bankruptcy court, protect me. I've got this creditor out here. I don't have any more money. I want to declare bankruptcy and end this thing.
Right.
And when the LLC is dissolved in bankruptcy, the judgment against it goes away. The outstanding liabilities are also dissolved.
Okay. I guess the reason I brought this up, because just thinking of the numbers, I've got $1 million liability and 50,000 errors and omissions seems pretty measly against litigation today.
Yeah, well, and that's, insurance brokers are helpful in this way. Their job is to sell you insurance, but their
Right.
job is also to understand all the products that they have on offer and give practical advice in terms of, like what the products can and what, cannot do for the business. So, the errors and omissions policies, I think, are sort of catch-all policies that often are used in situations where one of the other parts of the policy doesn't really apply. So it might be kind of a rare where there's a big claim that's based on E&O that isn't covered by some other professional liability.
Right. Right. Okay. Thank you.
All right, well, I guess we're out of time. Thank you all for coming. Feel free to come see us if you need more information or if you want to be connected to one of our attorneys.
And thank you to both of you for your time today and your expertise. We really appreciate it, and we know that our clients do as well.
I just want to say thank
Awesome.
you, Ryan, for your time and expertise today. Really appreciate it. I'm sorry I was a little late.
All good, Simeon. Thanks.
Everybody.
Thank you, Graham.
Yeah. Thank you very much.